Have you ever wondered how your estate plan and your retirement plan are connected? By the end of this video, you will gain clarity for your personal retirement plan and have action items to secure your retirement.
To learn more about securing your retirement and all the different elements you need to know, subscribe to our channel and hit the bell to be notified when we post a video every Monday. We have helped hundreds of our clients gain clarity and get on the path to comfortable and happy retirement. Now it's your turn. Let's dive in.
Merce and I had the opportunity to interview an estate planning attorney named Chess Griffin, and we answer a lot of questions when it comes to estate planning, and you can think about how that connects to your retirement plan. We hope you enjoy. Let's just take the average person. We don't have anything complicated. We don't have anything that we got to think about yet, but
Right.
what are the basic elements that I need to have in place, in your opinion, when it comes to an estate plan?
Well, that's a great question, Radon. And, I actually, when I talk to folks about this, the first thing I really do is sort of define what estate planning is. Because sometimes people reach out to me and they say, we have a very simple family. We don't need estate planning. But what I describe estate planning as merely the process of making decisions in advance, making sure those decisions are set out somehow in writing or some other way, so that other people can act for you in certain situations. And so these are decisions about family members, about assets, about kids, about where they go to school. It may be decisions about how one's wants sort of end of life matters to be taken care of, funeral arrangements. So all of these things kind of encompass estate planning. And so where I come in is, of course, there are some legal documents that I know we'll get to in a second that need to be prepared as part of the estate plan. But when people say, what makes up a good estate plan, I say it's the legal documents. It's making sure things like all the beneficiaries are correct on their retirement accounts. It also involves making sure, to the extent they want to, having funeral or cremation arrangements taken care of, which could be just simply no more than writing a letter to the family saying, look, this is how I would like my funeral to be, or something, something along those, some sort of guideline for the family. It can be making sure that the kids are set up, if something happens to the parents, for school. I've got some clients who want to make sure their college 529 plan is set up. All of these things kind of involve estate planning. And so when I meet with folks, what I try to do is try to figure out what's important to them. What do they want to accomplish? And then we try to, fit in the pieces of the puzzle in the right place.
Yeah. So, and it's definitely a lot to think through. So I got married 2 years ago, and then I had my first child this year. And so, every little thing that changes in your life, it makes you think about, well, how am I going to think all this through and make sure it's all done properly when I'm not here?
That's right.
So leading with that, you mentioned estate planning documents are
Yep.
the things that actually get it done. What are the main documents? And then we'd like to go into those, but what are the main few documents that you would say the average should have?
Sure. Well, I describe it as the three-legged stool of estate planning. The three basic documents that I really think everybody needs, almost without exception. There might be certain situations where somebody doesn't need one of these, but for the most part, most everybody needs a will, a durable power of attorney, and a healthcare power of attorney with a living will component. Those three documents really cover the basics. They do different things. There's maybe a little bit of overlap in certain places, but they're really three distinct instruments. And all of these three things really set out your wishes and put other people in control to take care of things for you. Because obviously, as long as we're all healthy and living, we can make our own decisions and manage our own affairs. But these three documents are intended to provide a mechanism for other people to act legally for you. And so those are really the basics. And I can certainly, I think we should go through those in some detail.
Yeah, so let's just take the first one.
Okay.
A will.
Yep.
Now, I've heard people say that they have, just something they wrote out,
Right.
a piece of paper and they signed it. What's the difference between somebody doing that and actually having a real document that is considered to be a will? Is there,
Right.
how would you view those as different?
Well, North Carolina law recognizes handwritten wills for under certain very limited circumstances. So that's called a holographic will, a handwritten will. And also, of course, as you know, some people do things online. There's LegalZoom and other places like that. And I always like to, I like to be practical and realistic. And as I say, those, it's better than nothing. And I can certainly explain what happens when someone dies without any kind of will, and that can be a disaster. So it's better to have something. But the wills that we draft, it's not just the document that we bring to the table. That's obviously a big part of it. We're constantly modifying the law. I mean, the documents to address changes in the law. So that's certainly part of it. But a lot of it is sort of the experience around seeing how these documents are actually used. So a good example in a will, in North Carolina, the general rule is if people own property, a house, and let's say they leave it to their 3 kids, well, the general rule is the 3 kids get the house. And that all sounds great off the bat. But what I've seen more often than not is that when the 3 children then inherit the house, one of them wants to live there, one of them wants to sell it, and one of them wants to keep it and rent it as an investment. And maybe the best thing to do would have been to just sell the house and distribute the money. Well, the 3 kids could certainly sell the house if they all agree, but let's say they don't. So one of the things we bring to our wills, or at least the discussion that I have with people when we do a will, is whether to include something called a power of sale. It's a very specialized provision that gives the executor the ability to sell the property without court involvement and distribute the money to the kids. That's not in a default online will, or it's certainly generally not going to be in a handwritten will. You've got to write it out a certain way. So a good will drafted by an attorney who has handled many probates over the years, who has seen these things play out, that's what we can bring. That's what any good estate planning attorney can bring, is sort of customized additions and deletions in certain cases. Sometimes we don't want something based on the actual clients.
Gotcha. So you mentioned having a will, but then you also mentioned this thing called a living will that can be a part of the actual will. So can you go into, everything that can be put into the will, and then why you would need something like a living will added in?
Well, the living will is actually part of the healthcare document. So we have the will that handles the assets in an estate when someone dies. The other 2 documents, the durable power of attorney and the healthcare power of attorney, those are the documents that are used while someone is still living. In the case of the healthcare power of attorney, as the name kind of sounds, it's where someone can make healthcare decisions for you. But the living will, to answer your question, Murs, the living will is part of that healthcare document, and that's where you can set out your end of life matters, how you want end of life decisions to be made, or who you want to make those decisions, under what conditions. It used to be that the healthcare power of attorney and the living will were separated. So it used to be, we used to have a 4-legged stool instead of a 3-legged stool. But in 2009, the law was changed in regards to healthcare documents. And now it kind of makes sense to combine the healthcare power of attorney with the living will into one document, which is what we do now. But both of those life documents, the durable power of attorney and the healthcare, the reason why those are so critical is those are the documents that would let someone make decisions for a client while they're living. The will is after someone dies, and that's important, of course, but we all are concerned, especially given the pandemic that we're in now, that, any one of us might be in a healthcare crisis at any time, and we might need someone to step in and make either financial decisions in the durable power of attorney or healthcare decisions. And so those 2 documents legally give someone the right to do that for you.
Okay, nice. So one of the things that I just want to make sure we're clear on, as far as with the durable power of attorney. So an IRA, for perspective, for a understanding, is owned by an individual, and you may have a beneficiary listed. But let's just say I'm married, and I have an IRA. Am I understanding it right? She cannot access that IRA without that power of attorney, in a sense of being able to make decisions and have to do things. So if I'm incapacitated, that's what that power of attorney could help that person do.
Exactly right. Yep. Yeah, a power of attorney actually is a very powerful document because you're giving someone the keys to the kingdom. The person you've named, and of course, spouses often name each other, but then there are often backups, alternates. But whoever is there can access your IRA, your bank accounts. They can sell your assets. They can make gifts. They can sign your name to a contract and bind you to it. They could, do all manner of things. They could change the beneficiaries of that IRA that you mentioned. All those powers are important. And we've had, I've been doing this long enough where I've seen it all at this point, and we've had all of those powers utilized. Speaking of IRAs, in powers of attorney, let me give you a quick story, quick example. I had a situation many years ago where it was a younger couple, and this wasn't in the context of an IRA, but rather life insurance, but similar. And the husband in this case was in a very terrible car accident and ended up dying from his injuries. And he was in the process at the time of the accident of going through underwriting for the life insurance, but he hadn't yet completed the beneficiary form. And he, of course, intended to name his wife as beneficiary, but he just hadn't gotten to that step yet. So when he was in the hospital, if he had died, let's say the policy was issued, but with no beneficiary named, well, the proceeds would have been paid, but it would have been paid to his estate. And he had significant creditors, and the creditors would have eaten up all of those life insurance proceeds. Fortunately, the wife came to me, and with the gentleman's power of attorney, with the power to change beneficiaries, she was able to name herself the beneficiary and submit it to the life insurance company. And that was in place when he died. So when he passed, the proceeds went to her directly and not the estate. So these powers, sometimes people focus on them. I've had clients say, wait a minute, whoa. I don't want someone to change the beneficiaries. And I get that. We're all concerned about bad actors, but that really gets to making sure we pick the right people, not so much eliminating those powers.
For more retirement tips, watch this video. Retirement Planning Checklist to a Worry-Free Life. Also, click here to subscribe to our podcast, Secure Your Retirement. If you found this video helpful, hit the like button, be sure to subscribe, and share it with your friends.